Hi, welcome to all of you who have joined us. I anticipate there will be others that join in the next few minutes. My name is Jim Devine. I'm the HR practice leader for Univest Insurance. Very happy to be with you all today. And I'm also very happy to have Mike Trachtman here with us. And Mike is a partner in the law firm of Wisler Pearlstine. And Mike and I have collaborated on presentations like this in the past, and I'm happy to be doing it again today with Mike on what I think is going to be a very content-packed next 1 hour. One of the things that I really admire about Mike is his commitment to the small to mid-size employer in his practice over the years, which has been focused a lot on employment law and employee relations and helping small employers with dealing with issues in their workplace. But Mike has also focused on being more like general counsel and so committed to that smaller employer world that he actually put pen to paper and years ago wrote this book, which I still have, and it's a wonderful resource. A couple of the mistakes that are covered today, and I think are really relevant today with the COVID-19 situation, is employers are losing the documentation war in some cases, and in other cases they're not taking action either soon enough or at all, and that's creating larger problems, making mountains out of molehills, as Mike refers to in the book. So Mike, very pleased to have you with us today. Mike is going to be with us in the second part of the presentation. I'm going to handle the first and really the first 4 bullet points, and it relates to the trends, what's happening right now with employment lawsuits as a result of the COVID-19, the pandemic situation. Some of the general causes that we're seeing, the most prevalent types of claims, and then some recommendations on how you might prevent some of those claims from happening in your workplace. Then Mike will take over, and I'm really looking forward to Mike's part of the presentation because what Mike is going to cover relates to very specific situations. In addition to some general guidance, it's very specific situations and how to deal with them. So, you know, I think that's going to be very practical guidance that you can take away and use right away. But one of the things I want to make sure that, you know, all the words on this slide basically boil down to that we're providing this information with the good faith expectation that you'll seek legal counsel when you need it. Although Mike and I are both attorneys, we're not here today to provide legal advice. And although you may take some of this back with you, we're going to make the slide deck available to you. And you may think it's very practical guidance and want to do something about it. Anything that kind of gets into that legal realm really should not be done without the advice of counsel. So I just did want to mention that before we get started. When it comes to the trends and then the best practices, one of the interesting things that I've seen is that we have kind of a counterintuitive situation that I would call it, because typically the employers with bigger pockets are the ones who are brought to court, but not so much now and with the COVID-related litigation. As you can see here, these statistics are kind of surprising to me, that 65% of employers have less than 500 employees who are caught up in litigation right now. And then a large percentage, you know, 38% overall are employers with less than 50. So I don't think it's a surprise that there's a lot of litigation related to disability leave and accommodation, because you have the laws that were put into place very quickly, and maybe with not so much clarity. The Families First Coronavirus Response Act, that is where the leave is occurring: paid leave, extended leave, emergency leave. And then you have situations that really by definition involve employers with less than 500 employees, because those are the employers the act applies to. So that's not that surprising when you really think about it. But what I think is kind of alarming, and you'll see the statistic in one of my next slides, is the prevalence of whistleblower claims, retaliation claims. That these are employees that are exercising a protected right. It's their legal right to say, hey, I've got back to work here and I'm not so comfortable that you're taking all the steps that you're required by law to take to protect our workplace and our workforce. And then raising their voice, and maybe they felt discriminated because they weren't brought back when others were. It could be a lot of things. And they raise their voice, and then they have some type of negative impact to their employment. Maybe it's that they're terminated, and that's where some of this litigation is coming from. And it's, to me, it's kind of surprising that it's that much. The wage and hour claims are emerging. I do say here that it's only 5%. It's not. It's more than that now. And these would be claims from employees who are thinking I should be getting overtime. My employer's not allowing me to work overtime, and yet, excuse me, I'm working late hours because I'm working at home. Sometimes I'm taking care of my kids during the day, and the hours just kind of extend. And meanwhile, I'm under this mandate not to work overtime. It could be that. It could just be some type of leave-related claim where they were supposed to get paid and they're not. And so they differ, but they are emerging now as employees understand their rights more. One of the things that I did notice too in the statistics is that some of the litigation in certain areas is actually lower, or it's slowed. It hasn't developed as much, and some of that has to do with courthouse activities being either limited or not available to be live in person at all. And then the EEOC, the Equal Employment Opportunity Commission, that was actually closed at the start of the pandemic for a few months. So I would say that we might see another spike, just like we've seen with the pandemic itself. Here you can see the statistics, and it's interesting that it's so consistent in terms of the growth over the past several months. And it does seem to sort of, be flattening out. But these are both state and federal complaints. And I think what happened early on too, although I'm not quite sure, is that when the Equal Employment Opportunity Commission was not fielding charges, maybe some of the employees turned to state to prosecute or to take action against their employer in state court. One of the things that's important to know here, and we don't have big litigation statistics in terms of how much employees are getting when they're settling their claims or they're getting verdicts, is because it has some of this hasn't played out yet. It just hasn't played out to settlement or verdict. Here's another slide on some statistics, and one of the interesting things here is no surprise on California, but New Jersey being number 2. And when I looked into that a little bit, what I found out is that New Jersey has some fairly liberal paid leave laws as compared to, say, Pennsylvania. And it has apparently a very active plaintiff's bar. So you have, a lot of plaintiff's attorneys. And so that has resulted in it really taking the number 2 position out of these top states. You can see Pennsylvania there at 64. It's not as active as some of the other states, but certainly worth noting. And then here are the type of complaints. As I said, you see that retaliation and whistleblower complaint at 569. Now, it's also interesting that some of these claims can have multiple bases for complaint. And you might have a workplace safety as well as a retaliation whistleblower blended into one. But it is interesting that employees are speaking up and they're taking action, maybe more so than in the past. When it comes to some of the causes, I think that a lot of this has to do with people being agitated over their circumstances. You combine that with employers not necessarily having clarity over their obligations. And employees may not even be all that clear on what their rights are. And so they go out and they say, I think I should have gotten this, or I'm pretty sure I should have gotten this and I didn't, or I'm pretty sure that my employer took adverse action against me and they shouldn't have. And then they combine it with, and I'm taking care of my kids at home and I'm overseeing their education because they can't go to school. And this is a really unusual, stressful situation. And I think that this is really sparking some of the litigation when you combine all those circumstances. And employers, companies always measure the risk of non-compliance versus the cost of compliance. And in normal circumstances, that's maybe a good analysis to make. But right now, with the heightened level of scrutiny over COVID-19, the additional regulatory environment that we're in, you really need to check that strategy carefully. Here are the with discrimination and retaliation whistleblower, a couple of things this poor little girl standing there in the graphic, that's actually a real case, and it's a case in the San Diego area of a woman who really, I guess, couldn't control her kids in the background of Zoom meetings, and the employer fired her. And apparently she'd been warned that she had to, keep the kids under control, couldn't do it, and she got fired, and then she sued her employer. And I don't know where that stands right now. I think it's still relatively new. But I kind of felt sorry for that little girl in the picture, but it is a powerful graphic. Some of the things that I think, it's just my observation, when you're not sure on how to deal with situations as an employer, when you're dealing with furloughs, calling people back to work, who goes out, who stays, sometimes politics and favoritism plays in there. And it's really important to take these actions that impact employees' employment and do it with a documented, objective approach. And a lot of times it's just been done kind of, based on a single decision maker's decision, which is the way some businesses run their operations. But here, it really pays to get advice before you do that. A lot of lack of clarity, as I said before, how to address these medical conditions and disabilities. I got a question the other day over, hey, I paid for the 80 hours of FFCRA leave. How do I get that back? I mean, I was supposed to pay that because of the law, but I normally wouldn't have paid it. So is there a way to get it back? Well, there is, but it's a tax break, as far as I understand. And the whistleblower, again, there are really two elements here. There is a protected right that someone exercises, and it's an adverse employment action. And when those two things happen, many times employees won't raise their voice. They'll just go on and they'll find another job or whatever, or they won't understand their rights. But right now, I think, again, kind of heightened and elevated scrutiny around this kind of thing. And employees are talking to each other on social media. And that's another impact of how this litigation tends to spread. Excuse me. Okay. Now you have the workplace safety, which we talked about. And one of the things that we're going to recommend here as part of this is that if you don't have documented policies that relate to returning to work, if you don't have protocols around safety, with maybe many of you have leased space in a building that you're going to be returning to, who is responsible for cleaning? What kind of protocols have you put in place so that that maintenance company is doing the right thing and they're documenting it? Some employers have been lax about that. It may be a family business where they know everybody, but have some newer employees, that kind of thing. We talked about workers' comp in the last webinar that we did. That's really kind of a moving target. It's generally not covered. Pandemic-related illnesses are not covered. However, there's certain occupations where it might be. And there are certain states that might have a more generous or lenient law than others. And then, as we talked about with employee leave and benefits, the FFCRA, again, Families First Coronavirus Response Act, That's been a bit challenging for companies to get a grasp of and to figure out how to comply with fully. Okay, some general guidance here in terms of prevention. I think the companies really, if they're not taking this serious to date, they have to be more diligent in addressing COVID, not just in terms of leave and some of the more obvious things, but in terms of, hey, we're going to call our employees back to work. We better be sure that we're providing them with a safe environment when they come back. And we need to communicate that to them so that they feel comfortable. Disaster recovery, pandemic response, pretty much with the audience that I guess we're addressing today, would not have been top of mind before COVID hit, and that's not unusual. But if anything was a wake-up call, I think it was that, so that you'd have more of a continuity of your business and you'd understand how to deal with things like furloughs and leave and what jobs are essential that need to be in the office versus what jobs can work remotely. That's a big thing right now. If you have job descriptions that are outdated and you haven't identified that this is an essential position that needs to work in the office, it's a good idea to go in and audit that and start to take stock of that in case this really goes on or spikes even further. Educating managers. Really take a look at, instead of just a memo or an email that went out, what did we do to educate managers in a session around Families First Coronavirus Response Act, or maybe the CDC guidelines, or maybe OSHA. But that's really, really important because those are the folks that are on the front line making the decisions along with business owners. And then really, just at all costs, avoid terminating or making adverse employment actions on employees who've lodged complaints without due process. If you investigate it and it's clear that there's a valid reason or justification for the employees to be terminated, there's an optics thing to consider if it's happening right after they lodge the complaint. But if it's something that's legitimate and that's the way it goes, I mean, that's unfortunate, but that has to happen. And then updating your relevant policies and following them. I mean, sometimes with employers, there is this idea of really documenting strongly policies and procedures, and then it comes to actually putting them in play. And if you can really get yourself twisted up if you make things too restrictive or really so black and white that there's no room for any gray or business judgment. Some additional action items, COVID point person, or as we say, a COVID captain. Make sure you have that person identified and that they're accountable to make sure that things like safety and protocols are followed. Remote work hours are a real challenge. And one of the things I would say is that you may have employees that are not reporting all their hours and they're worried that maybe it's too many hours or whatever the case may be. And that's a problem, and you need to get ahead of that. And then when you're granting or denying leave, I'd say err on the side of flexibility. Make sure that if you're giving somebody a break, they've got issues with their kids, they've got issues with their own health or the health of a family member, now is the time more than ever to be flexible there. Making recall, rehire decisions, make those based on documented objective business rationale, and then establish clear objective guidelines regarding flexible and remote working arrangements. And then just safety protocols and return to work guidelines. Document those and communicate them and educate really as well. I'm not going to go through all these policies, but again, this deck will be made available to you. And this is just a basic list of things that you want to make sure that you look at and update as much as you can. The one that's on here that I think is kind of interesting, and it may not be obvious, this is your drug alcohol policy. If you have a policy around that, it may have been geared towards language like zero tolerance. It may have been geared around things like, some type of observation in the workplace. And we've got a virtual workplace now, and how do you know if someone is under the influence? How can you tell, particularly if they keep their camera off while they're in Zoom meetings? If you're an employer that's requiring someone to turn on their camera, okay, the law is not really settled out on that right now, but you could implement that policy. And you observe somebody. What are you going to do? How are you going to deal with that? It's a very different situation now than it was in the past. Then there's some other things that we already talked about, but one of the things that in the benefits realm that's interesting development is telehealth coverage and whether that is something that you're going to cover. There are some new guidelines around 401k loans and hardship withdrawals and when you have to pay those back and how much you can take out. So there's a lot of things to consider here and make sure that you're dealing with these and documenting what you're doing. Very, very important. So here's a little pulse survey, and Emily, if you're out there and you can, there we go, flash this up. Just ask you to take a little survey as to whether you've designated a point person in your company. And this is an anonymous survey. It doesn't associate you with your answers at all. It's just something that's kind of a fun data point that we thought we'd collect. So take a minute and respond to this, and we'll see what the statistics are on that. Okay. Emily, hopefully we've gotten a number of responses. Okay. Wow, that's interesting if everyone can see that. We have 77% of our audience is indicating that yes, they have. No plans to do so. Not yet is a small percentage, 6. And then good, we've got some folks that are saying based on what they're hearing today, they haven't done it yet, but they plan to do it. So wonderful. Thank you, Emily. Thanks everyone for participating in that. Okay. Before I turn it over to Mike, I just wanted to make sure that everyone was aware that we have a HR helpline here, and the calls come to me, or I have an HR consultant, Chris Morrell, who works with me, and the calls are coming primarily to me right now, but Chris has got years of experience and very capable of handling workplace related questions. We're getting some good traffic on that right now, and basically if you don't have an HR person, or maybe you do, but the person is focused on things other than human resources because you're small, and it's the kind of environment where everybody has to kind of wear more than one hat, and you find yourself being unsure of where to go for help, and you're concerned about some of the potential HR liability that's starting to feel a little weighty and concerning. Give us a try. It's free. Your first call, you call us and you need some help. And generally what's been happening is that there we go, sorry. My 20 minutes are up, but I think it's the kind of thing where if you call, and it takes more than one call to resolve your issue, I'm going to help you with that. And I'm going to turn it over to Mike. And one of the things I'll say about Mike is we've been collaborating on this. And I like to say, look, I can get you down to the 5-yard line or better, and you might need some legal help to take it over the goal line. And that's where Mike comes in. And we've had those collaborations, and they've worked out really well. So I would encourage anybody who's listening, if you've got something that you really don't feel comfortable handling internally, call the helpline and let me try to help you. And then again, if we can help you get through an issue and it takes more than one call, we'll do that, and hopefully it makes a positive impression on you and you sign up at some point. But right now I'm going to turn this over to Mike. And I thank you for your attention so far. And again, very much looking forward to your part of the presentation. Mike, you want to take it away, and I'll make sure I advance the slides.
All right. Well, thank you. And thank you, Jim. Thank you, Univest, for giving me the opportunity to participate in this. As Jim mentioned, my professional passion for several decades has been working with the small business community. I feel pretty strongly about what that community adds to the country. You can look at the statistics in terms of where do the jobs come from, where do the patents and the innovation come from. It comes from the small business community. This has been a horrific time for small businesses, as all of you know, and I very much appreciate the opportunity to participate in this program and to assist as many small businesses as I can through Univest reach out efforts, which are quite remarkable in the context that I'm familiar with. So, as Jim mentioned, I want to talk about the employer liability risks that we face in a COVID world. Jim, next slide, please. So, as you may have heard, we just had an election. Things are changing very dramatically right now in terms of what the appropriate responses of employers need to be. Jim, you can go back one. There we go. One of the things that's happening now is that we're all in a context where the federal government has promulgated and Congress has promulgated certain requirements and states have promulgated certain requirements. It's a little bit of a crazy quilt in terms of trying to keep up with it. And to a certain extent, it will continue to be. But as a result of the election, it's pretty certain that the federal COVID response is going to be much, much more muscular than it has been in the past. The federal government will be much more involved in the COVID response going forward, and there will be still a great involvement on the part of the states, but less leave it to the states as being the approach of the federal government, as opposed to the federal government grabbing it by the throat to the extent that it can and moving this forward. So President-elect Biden and his appointees or prospective appointees are already talking about, for example, a national testing panel to control testing on a national level, controlling supply chains on a national level, invoking the Defense Production Act to produce more PPE as is needed in hospitals. As I'll talk about a little later, expanding in a much more aggressive posture with OSHA, maximum use of the federal government's interstate commerce authority, to get a little wonky. The federal government has tremendous powers based on its constitutional authority to regulate interstate commerce. It can invoke a lot of those powers via executive orders without Congress to control COVID. Messages, you're going to have to stay flexible and apprised and up to date. I do my best to keep my clients and friends up to date, and I know Univest does, and we'll join forces to do that in the future. But staying on top of what the COVID response is going to be and how it's going to change over the next 6 months or so is going to be crucial. Jim. So you're going to have increased federal COVID enforcement of requirements in 2021. Not that you haven't had a significant amount of enforcement, but I think it's going to pale by way of comparison. The EEOC, the Department of Labor, the OSHA departments have not been fully staffed over the last 4 years. They remain non-fully staffed. I think it's pretty clear they're going to get fully staffed, and there's going to be amplified enforced standards and requirements to stop not only the spread of the disease, but also to assist workers. And that's going to lead to more liabilities because federal government and delegated to the states is going to hold businesses' feet to the fire. And to the extent that smaller businesses do not have full-time staffs empowered to stay up to date with respect to all of these things and to handle all of these things, it's going to be a little bit of a burden on smaller businesses. And again, education and attention and flexibility is going to be the key, but this is coming down the pike for obvious, apparent, substantial reasons. Jim, next slide. Thank you. So, part of the thing that we're going to have in terms of this is federal workplace mandates that are going to go into effect, and you'll need to keep apprised of this. And these are national, what the government is calling national temporary employer standards, which we haven't had much of in respect to COVID over the last year. National employer standards, for example, on protective equipment, distancing, limiting the number of employees, mandating remote work when feasible. Up to this point, there's been a predominance of each state handling it the way that state wanted to handle it. COVID doesn't stop at a state's borders, obviously, and having two states abutting each other who handle the disease differently makes it very difficult for the control of the disease. Through executive orders and the like, and this is going to be a little bit of a political nightmare to deal with, but there's going to be a great push to have national standards that are going to be applied and enforced. Could extend into sanitation and housekeeping, training, kind of thing that Jim referred to, even down to air movement standards within offices, quarantining standards and the like. Again, federal government is going to push this. President-elect Biden has talked about a series of executive orders in the first 10 days of the Biden administration. Stay apprised, stay informed. We will all help you with that. Next slide, please. So let's talk in a little bit more detail with respect to OSHA. OSHA, Occupational Safety and Health Administration, is the federal agency that it's empowered to regulate health standards, workplace safety standards in the workplace. It has, by legislation, federal jurisdiction over you, over everybody who's listening. It's got federal jurisdiction to dictate what your workplace standards are in respect to OSHA and otherwise. The person who's primarily responsible for that down at the granular level in an OSHA administration is the undersecretary in charge of OSHA, and that position has been vacant for the last 4 years, as a result of which there has been not the kind of activity that some have sought and requested to control the disease. President-elect Biden has talked about the fact that one of the first things that he's going to do is to appoint an undersecretary in charge of OSHA to develop and enforce COVID response standards. They're also talking about budgeting through executive officer, adding approximately 250 or so additional OSHA inspectors. What's been happening in terms of OSHA enforcement in the workplace in a large instance of cases is OSHA has been doing things by what's been colloquially called a phone fax procedure, where somebody reports a violation, OSHA calls up or faxes the employer and says, we have a report of a violation, give us a response. The employer responds by phone or fax, and OSHA closes its file, in assuming that the response is either we have taken care of it or we will take care of it, without a great deal of follow-up. It's not going to happen right away because of the logistics, but there's going to be a much more strident follow-up with respect to workplace requirements, and companies are going to be made examples of in this context. That'll happen pretty quickly, I think, in certain respects, and more slowly as the inspectors are hired and trained. There's also a possibility about a permanent pandemic national rule that will go into effect. Again, that would be off in the distance. But watch very carefully with respect to OSHA and be mindful of the fact that not only will there be evolving standards, but there will be increased enforcement, which raises liability risks. Next slide, please. Paid leave. This has been something that's been on everybody's radar since March, when the FFRCA, as Jim alluded to, came into being. Basically, what happened at that time is that we had congressional legislation which talked about when you are required to pay people who are out due to a COVID-related instance. That could be because they've got the disease, they tested positive, they've come into contact with somebody tested positive, or they've got kids at home that they had to take care of because of school situations, and there are different ratios of pay and the like. All of that expires, sunsets as of December 31, 2020. Congress has not as yet expanded those paid leave requirements. They will be expanded. Just politically, there's no other way to handle this than to do that. There are obviously people that are suffering dramatically who are out of work based upon COVID issues. President-elect Biden has pledged to amplify this dramatically. And if he's successful in that, and again, a lot of this is some combination of executive orders, horse trading in the legislative process, Can't really say how and when and to what extent this is going to come to pass, but his stated goal is to require paid leave of 100% of wages up to a certain cap, $1,400 a week, is what's been talked about. Paid leave during mandatory quarantines, which is the way it is now, up to a certain point in time, being the extent of your FMLA leave. In addition, expanding this to cover your domestic workers, for example, to cover a caregiver in a home, for example, gig economy workers, people who are hired to the gig economy to do work at your business, for example, they would be covered by this paid leave requirements, which would be on your tab. Other certain independent contractors, not just employees, would be covered as well. Again, this is something to be extremely mindful of. It'll be in the news. It's going to be the whole COVID stimulus package and all of the other things that are being contemplated right now will hit the fan big time after the inauguration, probably even before the inauguration. President-elect Biden is talking about retaining the tax benefits that Jim mentioned. You can recover a lot of these costs through tax credits under the current law. A little bit complicated. You'll need some guidance, but it can be done fairly easily. And the talk is to retain all of that. The other thing to watch out here for is that this is not all going to happen at the federal government level. Some states, New Jersey being among them, California, many others, have stepped in and expanded the federal government's paid leave requirements. So watch out for states, and even cities have done the same thing. So the paid leave issues are going to be issues that create liability risks if you are not informed and apprised. Again, we'll help you stay there, but keep this on your radar screen. Next slide, please. Let's get into a little bit of Employment Law 101 so that I can help you understand how these basic principles of employment law will also affect you and create liability risks that you can avoid. First, let's talk about the ADA, the Americans with Disabilities Act, which has a great deal of heightened importance lately, particularly in the current circumstances. The ADA requires that if an employee has a disability, and the term disability is defined very broadly, that if an employee has a disability which interferes with job performance, you have to engage in an interactive dialogue with that employee. Again, there are standards for this to determine if there is a reasonable accommodation that will allow the employee to do the key factors, the essential functions of that employee's job, notwithstanding the disability. So basically, if somebody's got a disability very broadly defined, you are obligated under the ADA to try and find a way to get that employee back to work, even if it requires you bending over backwards, severely backwards, to come up with some form of reasonable accommodation to help that employee out. It's a significant burden that employers have to bear. It's becoming heightened in the COVID era, and I'll explain that in a second. Next slide, Jim, please. Jim also mentioned about discrimination and retaliation. Let's just define those a little bit as well. Discrimination in the law means making employment decisions that are based upon a protected category, to use the law's term, a protected category such as race, nationality, age, gender, disability, etc. You're allowed to discriminate against employees. You're allowed to choose one over the other. You're allowed to give one benefit and not the other based upon one being a better employee than the other, or harder working, or more qualified. You just can't make decisions based upon a protected category. That's what discrimination means. And retaliation means when you take an employment action, which is also ill-motivated, when it's based on, for example, as Jim mentioned, an employee who's requesting compliance with federal or state requirements, and you take the position that you don't really appreciate the employee holding your feet to the fire in that kind of a context, and you take some adverse action against that employee, that's retaliation. So we've got our terminology straight. Let's see how this is playing out in the specifics of your everyday lives. Jim. So this plays out in the issue of who do you have to allow to work from home in the COVID world, the whole remote work situation. Who gets to work remotely? Of course, we all know that the government can dictate that. In Pennsylvania right now, the government has dictated, the governor has dictated that all employees are to be allowed to work remotely unless it's, quote, impossible. Nobody knows what impossible really means. Physically impossible, practically impossible, impossible to do a really good job, but possible to do a not so good a job. I think all states have kept this understandably vague so as not to be splitting hairs with respect to this. But that's one basis for remote work. And then there are the mandatory leave laws when somebody tests positive or has been exposed to somebody who tests positive and the like. Those persons are allowed to work remotely, or at least they're excluded from the workplace. But then you run into a lot of other situations, everyday situations where my clients are calling me, literally not a day goes by, where the ADA comes into play. Jim, next slide. So, for example, employee calls you up and says, I've got to work remotely. You got to let me work remotely because I'm panicked about COVID. I'm really afraid of COVID in the workplace and I need to be let out to work remotely. Or I happen to be especially susceptible to COVID. Or I don't like wearing a mask, or I cannot wear a mask because of some condition and you need to let me work remotely. And you're in a position where, in respect to those particular employees, you really don't want those employees to work remotely. It compromises the ability of those employees to do their jobs. The problem comes in the fact that these kinds of requests, I've got to work remotely because I'm panicked about it, or I'm susceptible to it, or I can't wear a mask. Those conditions are starting to be construed as potential disabilities under the Americans with Disabilities Act. And when an employee brings that up to you, the bell may not ring, the red flag might not be raised that, whoa, I'm dealing with an ADA situation in these sorts of everyday employer-employee confrontations, but you are. And when employees raise these kinds of issues to you for purposes of demanding that they work remotely, you've got an ADA situation on your hand and a potential liability risk on your hand that needs to be handled with guidance. Next slide, please. There are lots of traps and pitfalls here. If these are disabilities and that require you to accommodate them in some reasonable way, and even if you start down that path to try to do it, suppose you really can't. Suppose that an employee's essential functions, suppose that an employee really has to be on the work site in order to do that employee's job. Raises the issue as to whether there are any reasonable accommodations, workarounds, switches, even if it costs you a lot of money to do it, that would allow those employees to work at home despite those realities. That's the burden of the ADA. Lots of companies call me and say, people don't work as efficiently at home. Even if they try their hardest, they've got kids in the background, to segue from what Jim said, or there's not as much collaboration, spontaneity in the workplace, brainstorming in the workplace. I've got engineering firm clients, for example, who confront these issues where people don't brainstorm as easily. What happens then? You've got issues that need to be confronted. There are no easy answers. Sometimes when there are no accommodations that can allow someone to do a job, the ADA may require you to give somebody an unpaid leave from the workplace to get them out of the workplace because of their disability. They can't work at home. There's no remote work, but you may be obligated to give them unpaid leave and protect their job in the interim. So these are things that need to be confronted in real time with guidance so as to avoid the ADA liabilities that are piling up right now in the COVID world. There are other kinds of things. I don't feel well and I might have COVID. Nah, that's not going to cut it. I live with people who are susceptible to COVID, so I want to be out of the workplace. Bona fide concern. Not particularly recognized in the law as triggering a legal obligation, but as a matter of management, you may want to accommodate those people. So these are complicated situations in the era of remote work that have legal implications in many contexts that need to be confronted as a matter of preventive medicine. Next slide, please. Discrimination and retaliation in a COVID world. So you've got situations where many employees are complaining, and Jim talked about this in his presentation, about being treated differently than other employees as tough choices need to be made. Some are permitted to remote work, some are permitted not to remote work. Some are having their job schedule changed, job schedule requests granted for job schedule changes and the like for various reasons having to do perhaps with childcare or disease accommodation. In companies that are experiencing furloughs or layoffs, some obviously are furloughed or laid off and some others are not. Choices have to be made. When employees are called back from layoff or furlough, obviously choices have to be made. And there are employees very on an uptick right now, on an extreme uptick, who are looking at those circumstances, sometimes in good faith, sometimes in bad faith, and saying, wait a second here. I asked for something. I wanted remote work. I wanted a schedule change. I wanted not to be laid off. I wanted to be called back. I didn't get my wish. You discriminated against me. I think you did that to me because of an improper reason, or you retaliated against me when you refused that request for an improper reason. So you're facing a discrimination or a retaliation charge, which says you did something for an improper reason when you know in your heart of hearts that you didn't do it, that you had a bona fide reason to do it. Now what? Next slide. It's all about documentation in the law. I hesitate to say, because it sounds so cynical, that doing the right thing is not enough in the law. You need to be able to prove you did the right thing. There are people who can make accusations and make them very convincingly, even though they're false. There are people who are really good liars, really good misrepresenters. You need to be able to create certain kinds of documentation for which you may need some coaching, because certain kinds of documentation are admissible in court and certain kinds aren't, so that when the time comes, you can prove you did things for the right reason and not an unlawful reason. And that's a crucial aspect to avoiding liability, not only in a COVID world, but in the world of employment law generally. You need to be able to show that you made your decisions based on a lawful criteria, and you need to be able to show that you can prove that you made your decisions. This oftentimes requires real-time guidance. I'll have clients call me and say, the following is happening. How should I document this? What should my documentation look like? And I can deal with them in real time for that purpose. The helpline that Jim talked about is perfect for this, absolutely perfect for this, and a tremendous benefit for all of you. Next slide. So your WORKSITE is another source of liability risks, as Jim alluded to. There are emerging standard operating procedures. The person in charge that we talked about in the survey, a go-to real-time resource such as the help line that Jim talked about, or other counsel that you can arrange to guide you in real time. Becoming aware of and monitoring and implementing CDC, state OSHA requirements, all of those things by now you're aware of need to be monitored. But you're running into some squirrely situations now that I deal with frequently among my clients, where people try to do their best and try and hit the marks, but they can't. What if you're in a rented building and your landlord won't go along with COVID requirements and your employees are complaining about it? What about when you need to send an employee to somebody else's WORKSITE and that WORKSITE is not complying with requirements? What about possibilities for separate work locations within a building for people shifting hours, PPE equipment, etc.? These can be tough rows to hoe and difficult problems to solve in real time. But as I mentioned before, enforcement proceedings in respect to WORKSITE safety are going to ramp up, and this is something that you really do need to pay attention to. Next. Similarly, dealing with infected and exposed employees. I think all of you have been down this road probably before. The standards are changing, and you need to be apprised of that. What do you do if somebody has a positive test, an employee? What if you do if an employee has been exposed to an infected person? And the definition of what it means to be exposed to an infected person is now changing and evolving. When do you have to pay employees who are put out of the workplace because they either tested positive or were exposed to someone else? What happens to the reactions of other employees in the WORKSITE? I get calls on this all the time, where employees are saying, we don't want to work. We now found out that Joe Jones had it. He was walking around in the WORKSITE. We don't know what's going on. Major reactions, morale issues with respect to that. And so too, if you're a WORKSITE that has third parties coming in, customers, contractors, etc., what do you do about that? So these are issues that need to be dealt with in real time with advice, or there are liability risks that are now evolving and will continue to evolve in the next administration. Next. So can you survive those kinds of potential liabilities? Just some pointers in addition to the ones that Jim pointed out. It's always healthy to involve your employees in planning and compliance efforts. They feel as though they're a part of what you're trying to do, and people who feel that they're a part of your efforts are less likely to bring a claim against you should something fall through the cracks. So I highly recommend putting together an employee committee or other input from employees for that purpose. Keep them invested in it. Current policies and procedures, obviously, as Jim talked about. Real-time guidance, you need that, as Jim talked about, as I frequently provide to my clients. Monitoring the workplace and documenting compliance, extremely important. Regulating third-party access to your premises. Dealing in certain contexts with waivers and releases when there's third-party access. Requiring the signature to waiver or release documents to limit your liabilities. There are a variety of preventive measures that you can take. We're all happy to provide you with all the guidance that we can in respect to that. Next slide. Wage and hour is really important as more than an aside, but I want to touch on it briefly. Jim raised some issues with respect to this. The other issue that I want to raise is the issue that's really a tremendous focus of the Biden administration. Made no secret about this for the last year. The question of when you've classified an employee as an exempt employee, someone who doesn't get overtime, are they really exempt? Or should they be getting overtime? Challenges to those classifications and changes in the classification criteria is coming down the pike. Same thing with respect to those people who work at your work site who you classify as independent contractors. Are they really, or should they be employees? Gig worker world is really big on this as well. Major focus, stated upfront focus of the Biden administration is to deal with that. And also with respect to your non-exempt employees, the ones who are paid hourly and are entitled to overtime, tracking their off-the-clock hours during overtime, during remote work, determining what time is compensable in terms of setting up, shutting down, etc. What remote work expenses are compensable, and your efforts to control overtime, all somewhat new, somewhat heightened issues in the COVID world we live in that will help you, if addressed, prevent potential liabilities here. This, I stress, is a major focus of the next administration. Next slide. Vaccinations. What do you do about vaccinations? This is obviously going to be a major issue. Can you require vaccinations under the current state of the law right now? You can, with certain defined exceptions, mainly in the nature of people who have health conditions and people who have religious objections. Other than that, you can require vaccinations under the laws that exist today. I don't know about next week. Question is, as a matter of management, should you require vaccinations? What will that do to morale? What's the nature of your business? Do you deal with outside, people from the outside world all the time? Is the potential to spread the disease for non-vaccinated employees? Well, that's a consideration. Or is everybody working socially distanced within one building where the risks are minimized? That's another consideration on dealing with this issue. So the vaccination issue is obviously going to be heightened. Are you a provider company? That's one thing. Are you, again, a solitary confined office that's very insular? That's something else, again. Has to be confronted. I think there will probably be some regulations coming down the pike, but obviously something to keep tabs on. Next slide, please. Another issue that really needs your attention, and that is protecting your key employees. This is the last key issue that I want to talk about, but you need to know that right now there's what I've ended up calling the COVID business plan, which is that companies who are failing in the effort to get back on their feet, given the economic pressures that they're under, rather than trying to reestablish themselves in the usual way, are taking the position of recruiting and poaching the key employees, the key know-how from companies who are more successful. There is a war going on right now for key valuable employees in specific industries. And the way it's been up to this point is that you've got non-competition agreements, which are fine in respect to that, but the world's going to change, I think. The Biden administration and many states and many judges have made it very clear that particularly with the stresses of COVID, non-competes are not going to be as enforceable as they used to be. Some states have already banned non-competes. President-elect Biden has talked about commissioning the Federal Trade Commission to ban non-competes or limit them in very substantially narrow circumstances. So non-competes may be on the way out, And I advise all of you that to the extent you rely on key employees, and many of you do, start now in terms of planning for alternative ways to retain key employees. I do a lot of work with a lot of companies with respect to the retention of key employees and in ways to protect your key information. Also extremely important, this protection of your key employees. Final slide. Just some keys, some things I want to mention in the effort to keep you staying alive. Cybersecurity is a big deal right now. Ransom attacks you've probably heard of. Remote work has opened up portals for hackers to steal confidential secret sauce information, both to sell to other companies and just for the purposes of causing you embarrassment. I deal with cybersecurity consultants on behalf of my clients. This is a big one. Reworking your customer contracts so that if you are caught short because of the pandemic and you can't, for example, meet a requirement or a deadline despite your best efforts because of the pandemic, you've got a contract that lets you off the hook as opposed to subjecting you to a lawsuit. Very important. And on the other side of that coin, the companies that you deal with, your vendors and suppliers and the like, they may have provisions in their contracts that get them off the hook, and you may not be able to afford that. Look at it. Negotiate COVID clauses that provide you with assistance should you get into COVID trouble with your lenders, with respect to your commercial landlords, in business transactions generally. You need to have out clauses. The typical so-called force majeure clause doesn't do it. There are going to be new programs, governmental loans, the next version of the PPP and SBA opportunities that are there to help you out, help you stay alive, stay apprised with respect to that. We'll help you. Analyze your insurance coverage and limits, something that Univest can do for you directly as well. But there are certain kinds of insurances that can help you in a pandemic world. Having said that, we're open for questions. I wish you all the best. Stay well and be careful.
Mike, thank you, and thanks to everyone for joining us today. Just taking a look and see what kind of Q&A we have. We have some questions here. Let me try to get this bigger. Okay. Yeah, there's a question about receiving a copy of the PowerPoint. Absolutely, for sure. We will send that out. Let's see. Do you anticipate whether or not the FFCRA will expand beyond 1231? Mike, I think we answered that, and we think in some form it's going to have to.
Yeah, it's a major priority for the Biden administration. So I think politically it has to. Neither party can be on the hook for not extending assistance to the masses of people who are in trouble right now.
Okay. Then we have any guidance for employers with essential employees, healthcare, and mandating the vaccine. I know that in the past, healthcare workers have had mandatory vaccines. And Mike, are you aware of anything that would change that? No,
I doubt very much whether the government would back off on the requirement that people who are exposed to other people in a regular course of business, particularly in a health context, would be able to get off of the vaccine. And the doctors that I know are expecting to get it, lining up to get it, and I haven't talked to one yet who's anything but eager to get it.
Okay, great. And then here's one. What would you say for employers who are having issues with employees abiding by company COVID policies? What would you suggest to avoid employer liability? I know that, one of those that we talked about was, whether to work remotely or work in the office. But generally, Mike, I think employers are free to create policies and enforce them. It's just that I think right now, where they're really sensitive COVID-related impact, there may be more of a challenge. Would that be about where you are on this, Mike?
Yeah, but this is where documentation is the key. You've got employees who are refusing to follow the rules. They're valid rules, they're bona fide rules, they're rules for the protection of your company and your employees. You've got employees who refuse to follow the rules, such as, and I've got clients where this happens all the time, rules to wear a mask, rules to socially distance. I don't believe in that. I'm not interested in doing that. The issue is, can you fire those people? Yeah. Should you fire those people? Yes, I believe you should, but you better put yourself in a position through documentation to be able to prove that that's why you fired them, as opposed to a potential accusation that you fired them because they were a whistleblower or for some other reason. This is where documentation becomes absolutely crucial.
Okay, here's another one. Thank you, Mike. Is it okay to have the employee use PTO time when out of work due to COVID? And I'll start that, Mike, and ask you to finish it. And I think it is. You have to separate what's paid time and what's available under your benefit plan in terms of leave. So you may have someone just say, I'm not feeling well, I'm out of my COVID time, but I still need, a paycheck, and I'm going to substitute paid leave under PTO. If that conforms with your benefit plan in terms of the amount of leave, then I think it's okay. But if it's just someone saying, I've got 2 weeks left and I'm feeling so great, I don't know whether I have COVID or not, I'm just going to take that 2 weeks. I think that, it would be just like in times where there wasn't COVID, and you could enforce your PTO policy accordingly.
The only thing I would add to that is that under the FFCRA, which is expiring on 12/31, but which I expect to be continued perhaps in a more strident form, you cannot force people to take available PTO if the law allows them to take paid leave. So that, for example, an employee who has to be quarantined at home under the current legislation, that employee is permitted up to 80 hours of paid leave if they've got it left under their FMLA entitlements. But an employer cannot say, no, you use up your PTO first. So keep an eye on those requirements. Deal with us on the helpline or otherwise to get the advice as it arises.
Exactly. I should have clarified that. Yeah, if somebody's out of their 80 hours and they want to use PTO and it's available under your benefit plan, then
do it.
They're fine. But you can't say use PTO first.
Yeah.
Yeah. I think we covered some of these. Are there any worksite liabilities for normally remote employees? Example, traveling salesperson. Not sure, other than if that employee were to travel and then come into the office, Mike. I mean, have you had any situations?
Couple scenarios. I mean, under basic OSHA principles, which will most definitely remain in effect, every employer has the obligation to provide an employee with a safe work site. Now, if that employee work site is off premises because they're a traveling salesperson or they're a repair person that goes to customer locations and the like, the employer still has the obligation to make sure that that employee has a safe work site, even if it's away from work. So there are potential employer liabilities for employers, for example, who are confronted by a traveling salesperson or someone else who says, hey, you're asking me to go into places that are unsafe, who are not following the rules. And an employer would say, look, just wear your mask, do your best, and get out of there as quickly as you can. There's a problem there. You have an obligation to provide a safe work site, even if it's at somebody else's work site. So I'd watch that one and get some advice from that point of view.
Great. Here's one, Mike, you had mentioned getting employees involved in some of the, decision making. Someone just asking for you to expand on that a little bit, and what, what would that look like?
It's an advisory committee. I mean, you can form the COVID-19 employee advisory committee, and a person of a CEO level or a COO level or someone at a high level in the company to manifest their desire to collaborate and cooperate with employees would attend those meetings. Some of them to keep minutes. You'd ask for suggestions. We're looking at. We've had some employees who are concerned about people not wearing masks and pulling the masks up over their noses. And the employer would say, what do you suggest? How can we do this? What would work? What would be most practical? What about shifting hours? What about enforcing social distancing? Getting employee input doesn't mean you have to go along with everything the employees say, but it gives an opportunity to have employees feel invested in the process. Other than that, the specifics will depend on the workplace, but the key is to get employees invested and to feel as though there's an open door in the process. Yeah, sometimes you run the risk where you've got to say no, but I think that risk is worth running in this context, properly handled.
Great. Here's a good one that we'll have a few more here, and then we'll, in respect to people's time, we can always close, and then you can feel free to follow up with us. I think the last slide has our contact information. Yes, it does. So anyway, here's a good question. Does the FFCRA run concurrent with FMLA? Mike, do you want to field that one?
Yeah, for the what, 22 days that's left in it,
Right.
It does, in the sense that you have a certain number of FMLA, a certain time, 12 weeks in a 12-month period, however you count it, and the FFCRA provides certain benefits within the ambit of that available FMLA time without expanding the amount of that FMLA time. The FFCRA also lowers the bar for eligibility to these benefits by providing that the employee only needs to have been employed for 30 days before being allowed to take those 80 hours or to take that time off with kids when the school is closed, et cetera. So yes, to those extents, it runs on a parallel course, somewhat changing, while at the same time staying within many of the boundaries of the FMLA. I would, again, pay close attention to what's going to happen in the next month, because the clock runs out on this on December 31, and we're all really looking closely at what comes next. Is there going to be a gap? Are they just going to extend it, which seems to me to be a likely scenario, until it's replaced? But for right now, we don't know what happens as of January 1.
Yeah, and I think one of the key things to remember is that FMLA is the job protected portion of leave, whether it's for your own serious health condition or for a family member. And the whole spirit of FFCRA is protecting jobs while you're out. So to that extent, it's kind of natural that they go hand in hand.
Yeah,
I think we'll take
one other. Let me just make one other point there. Watch the state that you're in, because there are states that add on to the FFCRA, and you need to pay attention to the state and to some extent the municipality that you're in as well.
Yep. Here's an interesting one. It may not have an answer here just yet, but as far as we'll take this last question, and I think we'll wrap it up. We've handled most of them. Some of them were repeated, and some of them we answered already. So here's one. With the expansion of OSHA staffing, do you anticipate they will set any guidelines for safety, technology, et cetera, for home offices? And if employees complain that they're not working safely because they don't have resources, are they covered?
Well, I anticipate yes, although I don't see that as happening anytime real soon. But again, under fundamental OSHA law going back decades, employers have an obligation to provide a safe workplace, a compliant workplace for employees. And if an employee is required or otherwise legally entitled to work at home, and there's something about that home office or workplace that would otherwise violate OSHA standards, I think even now, without changes in OSHA law, there are some risks to be run depending on the circumstances regarding an employer's liability to do something in respect to that employee workplace.
Yep. Okay. I think we'll wrap it up there. Mike, again, thank you very much. Thanks for everybody submitting so many good questions and for attending. We are going to run some webinars in the coming months, and we'll have information sent out about that. So stay tuned, and we will be sending out a link to the document for today that everyone who attended will have an opportunity to have and to keep. So again, thanks very much. We really appreciate it. Mike, Emily, thank you all.
Thank you. Stay well. Bye-bye.
Bye-bye.